I'm Kimra Major Morris, intellectual property attorney. Here are the top 5 mistakes businesses make without legal counsel. Number 1, selecting a weak brand name. Generally, common terms, phrases, last names are not protectable. Children's books, for children's books is, for example, not protectable. However, what we call fanciful terms, made up words like Xerox and Exxon to promote products and services, not only is it memorable, but it's legally sound. You don't want to have something weak and then have to rebrand later because the thing you chose is not protectable. Therefore, engaging trademark counsel to confirm your brand strength is highly recommended. Number 2, failing to conduct a comprehensive search to confirm conflicts. Comprehensive searches give us information about what's active and what's inactive in the marketplace. We can learn strategy from this because if something's inactive, we want to know why it's inactive. An experienced trademark attorney will get on that and investigate previous filings to find out why they were denied or abandoned. Why aren't they active? Without this insight, then you as the business owner could file a trademark application and be waiting 10 to 12 months for a trademark registration that may ultimately be denied. By this time, your website is up, you've got business cards out, you might have vehicles with signage on them, a storefront sign. Nobody has time to rebuild all this stuff when you could just simply do the comprehensive search at the beginning to make sure you have your blueprint for a successful registration. Number 3, failing to file state or federal trademark applications. It is true, the very first person to actively use a trademark in commerce has the superior trademark rights. If you want to enforce your trademark rights nationally, because these are territorial, so U.S. trademark is for U.S. territories, you do need a registration. You would be surprised about the people who open businesses and expand and never file trademark applications. What they have is common law trademark rights, but they don't have enforceable rights in some cases because they have not acquired federal trademark protection. If you go to social media platforms and report copycats, they won't take the copycats page down if you can't show a federal registration. A reason to have a state registration might be, let's say you have a food truck. Then you can protect yourself locally if you don't want to invest in a federal application. The main thing about this is not only the value in your brand, but sustainability. You want to be able to stand for years and decades to come. And I always say you wouldn't build a house on land you don't own. So don't open your business and do all the things, but then you don't own the brand. It's extremely important to consult with trademark counsel to make sure when you file, your intellectual property portfolio includes the correct registrations, because you might need global registrations. Because if you're doing business globally, then you only have protection in the US, you're going to be at a disadvantage. But some protection is absolutely better than no registration at all. Number 4, engaging a PR firm to announce the brand before the brand is protected. We can't wait to tell this good news. However, in doing so, before we have initiated registrations for copyrights and trademarks, it is unwise because we can see you. We can see the people who have filed for trademark registrations. And if you have a big press conference and you have not filed your registration, others will do it first. And then you'll have to spend money either stopping them or spend money trying to minimize the brand confusion. And it's just not good to start off with people wondering if this is your website or someone else's website. What if you have a nonprofit and others are doing fundraising because you announced this before you establish the right to control the website or the content? Number 5, failing to register copyrights. Copyright registrations are similar to insurance for cars. If you're on the road and you have an accident, you cannot recover if you don't have insurance for your long-term issues. Typical copyrights for businesses include company photos, videos, blogs, newsletters, and with AI and all of these remixes of our creative content, we do ourselves a disservice by not engaging counsel to register the copyrights for us. They are as little as $65 for the filing fee, plus your attorney's fees, of course, and you can bundle these things before they're published. So if you're thinking, oh my gosh, I have way too many things that have to be registered, you can actually bundle unpublished works and save a lot of money while protecting your creative content. You own it from the moment you created it. But without a registration, you're not allowed to sue anyone for infringement. You're not allowed to recover attorney's fees. You're not allowed to recover what we call statutory damages. Those are fines that people get for copying your work. But that is a big gap in what business owners should do and what they actually do. Thank you for tuning in. For more information about intellectual property and what business owners could do to put themselves in stronger positions, reach out to me, Kimra Major Morris, at majormorrislaw.com.